Hello, fellow law nerds. Welcome to a special reaction episode that is live. Very exciting. An episode of Boom Lawyered, a Rewire News Group podcast hosted by the legal journalism team that's live and in your face and wants you to know that race exists and Black people, we still exist. Amazing, I know. I'm Rewire News Group's editor at large, Imani Gandhi.
And I'm Jess Piccolo, Rewire News Group's executive editor. I'm so excited to be live. I stepped on my own line immediately. This is amazing, though. Rewire News Group is the one and only home for expert repro journalism that inspires you to, first of all, give it up to Imani Gandhi for live tweeting the downfall of affirmative action with gifts and humor and grace. The Boom Lawyer podcast is part of that mission. A big thanks to our subscribers, a welcome to our listeners, and hello, viewers, live. We're live. We're live, Imani.
It's very exciting.
We're live. Woo, okay. But why we're live isn't the greatest, all right? The Supreme Court is actually still now. We had originally scheduled this for what was supposed to be the end of arguments, but they're having so much fun. They're still going. Today, they're hearing arguments in two cases that will likely overrule more than 40 years of precedent regarding race-based affirmative action in higher education. It's a mess.
It is a mess. Both cases, Students for Fair Admissions versus Harvard University and Students for Fair Admissions versus University of North Carolina, were filed by none other than Students for Fair Admissions.
Wow.
Which is it's an anti-affirmative action organization that is backed by a lot of dark money, but it's led by conservative Edward Bloom. And just so you guys will know who Edward Bloom is, do you remember Abigail Fisher? You know, Becky with the bad grades? The woman who lost her case in 2016, she tried to overthrow affirmative action. The court was like, nah, dude, affirmative action, it's still legit. Well, here we are again with Students for Fair Admissions back in front of the Supreme Court, asking the Supreme Court to ban the use of race in admissions, despite 40 years of precedent. 40 years of precedent in which 12 justices nominated by 9 different presidents have already ruled that schools may consider race as a factor, not as like, an ipso facto situation, but just as a factor when considering school admissions.
So, Imani, before we really get into the nugget of the case here and the details here, race-based affirmative action has been around for a long time, like 40 years plus, right? Why today it's Halloween. Why are we hearing these arguments today? What's going on?
40-year itch. That's my answer. Because over the last, couple of terms, we've seen the court overrule precedent, and it always seems like that 40 years is the target. It happened with the Union case, and I think it was 2019, remember? It happened in Roe versus Wade. That's a 40-year precedent. I believe it also happened, was it the gun case was also a 40-year precedent? I don't know what the deal is with this court in 40 years, but I guess it is decided that after 40 years, all bets are off. But the actual serious answer is that we have the Fed Sox 6 now, right? The conservatives have made it their main goal to capture the court so that they could do stuff like this, right? So that they could move forward with this project of white dominance and white supremacy. So that's why we're hearing it now, simply because they can. And let me tell you how bizarre this is, right? So the University of North Carolina case, which is one of the cases, didn't even make it to appellate review.
What does that mean? Hold on. What does that mean?
Okay, so when the Supreme Court grants cert, right, a party says, hey, Supreme Court, the appellate court got this wrong. Can you please review this case? What the Supreme Court did in this situation is they granted cert before judgment, which means that the Fourth Circuit Court of Appeals never weighed in on this case. They just skipped that level of review and went straight to the Supreme Court. And the Supreme Court was like, yeah, we'll take it. Why? Because there are no rules. They're not abiding by any of the institutional norms that they used to. Norms like, let an appellate court decide the case before you take it.
Right. And I mean, it would probably be good to point out that the Fourth Circuit is one of the final circuits left that is not completely overrun by Trump judges. But let's talk about the two cases real quick so that folks know what the court was hearing arguments about. And then we can talk about the walkabout through what is race even, Imani, that the Supreme Court justices did today. All right, so we had two cases before the court. One is SFA versus Harvard. And in this case, SFA is challenging Harvard's admission practices under Title VI of the Civil Rights Act. And they're arguing that Harvard intentionally discriminated against Asian American applicants and that its policies fail strict scrutiny and are unlawful under current precedent, which current precedent schmessed it with this court. Okay. So, real quick, Title VI is the federal law that bans discrimination on the basis of race in public schools and any sort of federally funded institutions of higher education. All right. In this case, the district court and the First Circuit Court of Appeals, so we actually had some appellate review here, sided with Harvard, finding that Harvard's policy survived strict scrutiny. So it was hella constitutional, right? That's basically
hella constitutional. Is that a technical term? Yo, this shit's hella constitutional, son.
But also, and most importantly, that the statistical analysis didn't show any bias against Asian American applicants.
Yeah, that's the Harvard case. And just so you know, the court is probably right now listening to arguments in the Harvard case. They're just now getting into those arguments.
They were supposed to be done with all of this, but they're having so much fun. They're just going to do this all day. All week, maybe. Who knows?
Who knows? So the second case, the one that we actually were able to listen to oral arguments because they heard that one first, is Students for Fair Admissions, SFFA versus University of North Carolina. And SFFA is challenging UNC's admissions practices under Title VI, just like Harvard, but then also under the Equal Protection Clause of the 14th Amendment. And the reason why UNC is making Equal Protection Clause arguments, but Harvard isn't, is because the 14th Amendment, because UNC is a public institution, it's a public university, therefore the 14th Amendment applies. Harvard, 14th Amendment doesn't apply because it's private. But SFFA is arguing that UNC's race-conscious policies discriminate against white and Asian American applicants in favor of Black and brown applicants. And I just want to say, just the phrasing of that discriminates against white and Asian American applicants. And we saw that a lot in the arguments today when people were asking questions and responding to questions by talking about white and Asian American applicants, as if this case wasn't purportedly brought on behalf of Asian American students, right? Asian American applicants, and those who felt that they were being discriminated against, or rather, those who conservatives convinced were being discriminated against, when really they're not. It's really, mediocre white folks and white women who have benefited the most from affirmative action. But what is critical, and what I really loved to see this morning, is that Justice Jackson was able to participate in the arguments regarding the UNC case. And she is not participating in the Harvard case because of her ties to Harvard, which I still think is crap. But whatever, her ties to Harvard, being a Black woman on the bench, she's held to a higher standard. She holds herself to a higher standard. And so she recused herself from Harvard. But it's not a big deal because she was there for the UNC arguments, and she made all of the points that she needed to make. And we're going to get into that. We are going to get into that.
Was she there?
Woo!
All right. There's a lot of policy though, right? Like this was an argument that was mostly vibes.
Vibes, hubris, boxed wine, maybe just like a soup song of whiskey. I don't know what was going on this morning, but they were having, like you said, just a proper walkabout.
They really were, and so one of the things that struck me the most is that we could boil this down to a case about white grievance, right? As you said, it was sort of the checkbox. Are we talking about Asian American students? I don't know, but truly it was about white feelings. And Justice Jackson, I think, probably honed in on this the most with regard to questions of standing, right? And can you bring a case if basically the folks challenging North Carolina's admission policy couldn't show any real injury? And she was like, I know you feel hurt, but are you hurt? And if you aren't actually hurt, you have no standing to bring a case.
Right. And if you have no standing to bring the case, then you have no remedy. And then you messaged me in the middle of these arguments, something like, KBJ on fire says that white grievance isn't redressable or white feelings aren't redressable.
Yeah.
Like because you feel bad or because you feel that someone, quote unquote, less qualified took your spot, doesn't mean you were actually harmed if it turns out that the admissions process did not use race as a factor, as an if not but for factor, right? Like that's just not what is happening. The lower court, well, the one lower court that heard the North Carolina case found that that wasn't happening. But what SFFA is doing is just basically relitigating facts.
Yeah.
Just relitigating facts at the Supreme Court.
And so, look, I mean, we make a lot of predictions on this podcast because we think that probably we can. And I will say that there's clearly enough votes to end race-based affirmative action programs in higher education. The question is, do we end it immediately or do we find some kind of finish points? Or, is it something along the line of, do we create such a race neutral policy that up is down and black is white is black?
Look, clearly this has been a project that has been ongoing since at least a year ago when the great critical race theory debacle of 2022 began, which basically purports to say that talking about black people is essentially racist. Teaching history is essentially racist.
Yep.
And I think that the larger agenda here, right, is to talk about race on white people's terms, right? And race is only a factor when white people say it is, right? So if a black person gets a spot and a white person doesn't get a spot, that's a zero-sum game. And we heard a lot of talk today about a zero-sum game. Like if a black person gets a spot at the University of North Carolina, then a white angel loses its wings. Like that's essentially what the argument was. And it's very frustrating. We're entering a period where Black people, brown people, indigenous people are being removed from society, removed from the ability to be socially upwardly mobile.
And we can contrast this really well between Justice Alito and Justice Jackson, right? Justice Alito specifically, I talked about race as a factor in admission as a +1 and straight up asked counsel, well, then doesn't that mean it's a -1 for white applicants, right? That implies a bias against white applicants, which is bananas, okay? Because it is, as you said, it's not a zero-sum game. But then you had the hypothetical by Justice Jackson, which is a black resident of the University of North Carolina wants to stay in state and attend this school that their family has been historically excluded from, in part on the basis of their race, and they don't have the ability to talk about that experience. What does that mean, right? That hypothetical immediately grounded it into the reality of race and experience and the really weird ways that the white conservatives on the bench were talking about it. Like Justice Alito was like, so here's my hypothetical. Let's say you're an African immigrant and you move to rural North Carolina. You don't actually experience racism, but there's strong cultural differences.
What are you talking about? As a black immigrant moving to North Carolina, you don't experience racism. Racism doesn't ask what country you're from. Racism looks at your skin color and categorizes you one way or the other. That's why, the quote unquote light-skinned black people still are subjected to racism because they read as black. White people code people as black or brown and then interact with us based on that. And when they seem to think that our blackness or our brownness is gaining us some advantage, when really it's not an advantage, it's just a bringing up to the level of white people, right? A sort of fomenting of equality, then suddenly we can't talk about race.
Right.
You made up race to discriminate against black people. And now when we want a modicum of equality, suddenly race doesn't matter. And a black African immigrant from Nigeria who's moving to freaking, I don't know, wherever North Carolina isn't going to experience racism. That's absolutely absurd. That's literally absurd.
I mean, Alito was just an exercise in racial absurdity all day.
Absolutely.
Oh, but can we talk a little bit about Justice Amy Coney Barrett wanting to experience racism, please?
Listen, I can't with this woman and her black children who I don't know what's going on in that household, but I don't understand. No, I do understand. I don't like the ways in which she seems to be unwilling to step inside the shoes of her children and perhaps look at the world from that perspective.
Yeah.
Because if you do that for a moment, really sit them down and talk to them and what it must be like in Indiana or wherever it is that they live, whatever, rural, primarily white enclave in which they live. What's that like being the black child of a white parent in that region?
Yeah. I mean, the idea of experiencing race, right? It's just, what does that mean? I mean,
Rachel, as you said, it's like Rachel Dolezal shit.
It is. I was singing to Imani in the chat that this is the equivalent of Amy Coney Barrett going, "I want to know what race means," right? Like
it really is.
It's just bizarre, but
right.
we expected bizarre from them.
Okay, so I have a question for you.
Oh boy, I don't know that I'm prepared.
Do you think this decision could extend outside of colleges and universities to other situations, to workplaces, to schools, that sort of thing? Is this going to stop with higher education or no?
No, Justice Barrett even suggested so herself, right? She had the whole line of questioning around affiliate housing and things like that. One of the things that we know is that so let me back up and explain a little bit of the law here. So there's a statute at challenge here, Title VI of the Civil Rights Act, and that deals, like I said, with race in admissions, and it's part of a bunch of civil rights statutes. So there's Title VI, there's Title VII we talked about last week in the Bostock decision. That's the federal civil rights statute in employment. They're all supposed to be kind of read together and along the same ways. And so if we have a race colorblind approach to admissions in higher education, we will soon see a race colorblind approach to remedies in housing discrimination, for example, or remedies in employment discrimination, possibly, or, remedies in public accommodations. There's no end point, truly, once we read out the original intent of what was going on in not only the 14th Amendment, and it's wild to be on the originalist side here, but in Title VI of the Civil Rights Act here. So absolutely. And it's not even like they'll be okay with the race neutral test that the court cooks up at the end of these arguments, right? The SSFA lawyer basically said, hey, we plan to challenge any race neutral policies too. And even at one point suggested it would be fine for universities to put their thumb on the scale for male applicants. So like the gig is up. They plan on rolling it all back.
Not just for Black folks, but for women too.
For women too. For anybody who's functionally not a white guy. And that's basically what they said in arguments. But let's get back to race-based affirmative action here for this. Because, Imani, what happens when they do away with affirmative action in college admissions policies? I think we heard the justices try to get to that a little bit, but really, what happens? What does this look like?
The enrollment of Black and brown students will plummet.
Yeah.
It will just absolutely plummet. I remember when I was applying to law school, those many years ago, and it was maybe 97, 98 when I was looking at law schools, and California had just passed Proposition 208, which plummeted the number of Black students at the University of California, Berkeley, which is where I wanted to go, which is where I got in. And I wrote a letter saying, yeah, I'm not coming because of Proposition 208, because I don't want to be the one Black kid in the constitutional law class who's expected to speak for my community, quote unquote, on all issues related to Black people. That's and that's a situation that Black people are put in anyway, because even with affirmative action policies, even with considering race when trying to mold a more diverse student body, there still are not a lot of Black kids that end up at primarily white institutions, right? These PWIs. So you still are in a place where you are kind of expected to speak for your community, where you are flooded with white high school kids who may have never met a Black person before they got to college. And now you're rooming with one and they're like, what's your fucking deal? You know what I mean? Like that's not a comfortable That's just not a comfortable place for me, and that's not a place I wanted to be. So I said, you know what? I'm not going.
That I mean, I obviously can't even imagine as a white woman, what that even experience was like. Also, I appreciated that we had the Solicitor General in these arguments talking about what this means beyond just what we're thinking in terms of admissions policies and the effect that this has pipelining for things like service industry and the military. I think about these things a lot. So do you. And that was an argument that I hadn't even really thought about, was how upending race-based affirmative action programs will have the effect of whitening the military pipeline. And what that means at this moment for democracy right now, when we have seen such an infiltration of white supremacist forces within military and services, like that sent a chill down my spine when I was listening to those arguments, because that was another layer that even I was like, and there's a whole democracy attack. But of course there is, because, right, isn't that the whole argument again that Justice Jackson was making, is that diversity is inherently a part of the democratic exercise, and if
Right.
we are anti-diversity, we are anti-democratic.
And we're also anti-fairness, right? We're
Yeah.
I mean, Kagan talked about that quite a bit when she
Oh
talked
yeah.
about the pipelines for leadership, right? The pipelines
Yeah.
for leadership in business, in medicine, in law, in politics, in government. These are all places like the University of North Carolina and Harvard University, these institutions of higher learning. They are pipelines for people to maintain, to get to these leadership roles. And if Black and brown people are excluded from these universities, then they're excluded from those pipelines, right? And by the time
Yeah.
Black and brown kids get to school, they've already been excluded from opportunities, right? I mean, Sotomayor talked about that, about the ways in which schools are under-resourced, schools in, Black and brown neighborhoods are under-resourced. We're seeing just a tremendous attack on public education right now, banning books and that sort of thing. So if you're in a public school where you're not even getting a full education, then once you get to college, you're already a little bit behind. And then if you can't get into a good college because those colleges, or the college that you want to, because those colleges are not taking race into account in order to develop a more diverse student body, then you're asked out of life, essentially. And how is that good for democracy? It's not.
It's not.
It's really not. Can we talk about originalism though for a moment?
I mean, sure.
Can we just?
Okay.
Because Jackson was all over it like brown on rice.
Mhm.
Kagan was all over it like white on rice. It was just, what do you think the originalists would have to say about this? And you heard the attorneys for this Strawbridge character, the attorneys for SFFA, saying that the Constitution is colorblind. The 14th Amendment was always meant to be colorblind. And that is just an abject lie. It is not true. The 14th Amendment is a Reconstruction Amendment. What we were trying to do, reconstruct the country after the Civil War. That was not a race-neutral exercise. That was not a colorblind exercise. The Freedmen's Bureau, when they wrote all of those laws that were supposed to help Black people, which then Andrew Johnson was like, we're not doing that. Those were race. Those are race. What's the opposite of race neutral? Race
conscious.
Positive. Race conscious. Thank you very much. Those were race conscious measures because we were coming out of a period where how many hundreds of millions of people were, not hundreds of millions, how many millions of people were enslaved? 4 million slaves. How do we bring formerly enslaved people into the fold to grant them equality with white people? You give them extra shit. That's what you have to do. That's the only thing that makes sense. And that's not even me just saying that trying to be extra woke, right? Unless you consider the framework, the architects of the 14th Amendment woke, because that's what they intended.
Yeah.
Right. And you're never going to get the originalists on this bench to even come close to admitting that. You're never going to get Clarence Thomas to admit that the 14th Amendment was a pro-Black amendment.
No. In fact, Justice Alito was so upset about that he kept going back to the one drop rule. How Black is Black? How Black is Black? When will we know that you are actually Black or white? Right?
And can we talk about how that does not bode well for this nonsense that Louisiana is trying to do, where they're trying to redefine what Black is for purposes of voting rights, for purposes of districting, right? This idea, and And a lot of this sort of race neutrality language, this color blindness language, really harkened back to the Merrill v. Milligan arguments, right? The voting rights case out of Alabama involving redistricting, where Alabama was trying to say that their maps, which drew one majority Black district in a state that is 27% Black, that when trying to figure out whether or not Alabama could draw an additional map, a second map that was majority Black, you had these clowns in court arguing that that was a race neutral exercise, that you could try to figure out a way to have a majority Black district without asking who's Black. It doesn't even make any sense. And so you have the same thing here where you're trying to just whitewash history, whitewash textualism and originalism in favor of this white dominance project. And it's just the level of hypocrisy. Like, I know you're never going to get Alito or Thomas to admit that hypocrisy, but just so you know that hypocrisy exists, right? You, viewer, I'm not pointing at Jess knows, but just so the viewers and listeners know that it is abjectly hypocritical, and you should honestly point out how Justice Jackson, again, is doing originalism better than originalist. Justice Kagan is doing originalism better than the originalist. But the point is originalism is never for the benefit of Black people. Originalism is for the benefit of white people. And that's how it's going to be. And that's how that's what we're looking at here.
Always. Can I talk about Brett Kavanaugh's bad faith for a hot minute here? Maybe 2.
Yeah.
3 or 4, depending on if the spirit moves. So okay, obviously he is going to vote on the side of upending race-based affirmative action programs. But I loved how he waltzed in and was like, I want to understand this argument that religious institutions are going to have a RFRA claim to ignore our ruling that they can't account for race because they are so interested in considering race because racial diversity is so important to their mission. Because it's so important to their mission. Evangelical schools are convinced that racial diversity in their ranks is a critical mission.
Yeah, that's happening.
I'm just going to go ahead and call bullshit on that.
Yeah. That's happening.
So 2 things. 1, we should be very terrified because that is a clear pipelining. Okay. So 1, it's a signal that the court is going to upend race-based affirmative action program. But Kavanaugh is also signaling what conservatives hope to do, and that is to pipeline students out of other institutions like the University of North Carolina, like the University of Virginia, like University of California, Berkeley, like the University of Wisconsin, high-end state schools that have traditionally been pipelines for upward mobility. They want to move them into religious institutions.
But also the flip side of that, which of course the court would never accept as a legitimate reason, right?
Yep.
But what if like an HBCU views, obviously HBCUs are taking race into account, but let's say like there's an HBCU adjacent school, right? Like not founded as an HBCU, but let's say there's a religious school that thinks that diversity is a part of their mission. Do you think this court is going to accept racial diversity as a sincerely held religious belief?
I'm
going to go with no.
I do know that Justice Barrett was very concerned about the possibility of conservative students being discriminated against based on their religious beliefs at public institutions.
Because that's happening too. That's a thing that is actually happening right now. The bad faith is what's so frustrating, just not with these oral arguments, but with this term generally, because you can't take anything that they say at face value, right? You can't take anything that they say as being grounded in fact, because they're making up their own facts and they're making up their own laws and rules as they go along in order to get to the place where they want to be, where the Federalist Society has told them they need to be.
Yeah. One of the things that cracks me up in a certain way about the conservatives' insistence on going to this colorblind constitution, which we are going to hear all term. This is the new thing, is the Constitution is colorblind, and it's literally a way to, as Imani has been saying, erase the progress of Black and brown folks, is that the conservatives basically want a Google invite for the end of racism.
They do. They do. Oh my God. So let's talk about this, right? So in 2003, the case Grutter versus Bollinger, right? Grutter versus
Yes.
Bollinger. That's the case that is, that said affirmative action is okay. You can take race as a consideration when you're
Mhm.
talking about admissions if there are no race neutral alternatives available.
Yeah.
Which, and again, you got to harken back to Merrill v. Milligan. How are you
Yep.
supposed to achieve racial diversity with race neutral alternatives? I mean, yes, you can use socioeconomic class to a certain extent, but race is a simulacrum for race. Like, there's just no getting away from that.
Right.
And
Right.
so it's just very frustrating to listen to them try to act as if there is a way to get away from that, right? So Grutter v. Bollinger says you can do this.
Mhm.
And now these, the SFFA is saying, no, we can't do this anymore.
Right. Right. And Roberts is like, "Okay. I hear that." Oh,
I was just going to say.
yeah.
And so in Grutter, Sandra Day O'Connor, right? She
Mhm.
says, yeah, okay, we're going to do this. If there are no race neutral alternatives available, you can consider race. But you know what? We think that there's going to be a point at which there will be race neutral alternatives that are as effective as
Mhm.
race-based considerations, right?
Right.
And she just said, we think maybe in 25 years.
Yeah.
So that's 2003. 25 years takes us to 2028.
Yeah.
And so what Brett Kavanaugh and Amy Coney Barrett and all these people were talking about is, well, O'Connor said there's a 25-year deadline. The
Yeah.
SFFA attorney said there's a 25-year deadline. It wasn't a deadline. It was essentially we think that things might be better in 25 years. Let's take another look. Not in 25 years, racism is going to be over. And at that point, whites are going to rule again. It's so disingenuous. But like, as you said, they want to know what day they can mark on their calendar as the day that racism dies.
These justices.
It's such bad faith and it's so ridiculous. And it also harkens back to this, just John Roberts with the only way we can get over race is if we stop talking about race. That's just a nonsense proposition from the outset.
Yeah.
It's a proposition that is grounded in white grievance, right? Because they don't want to talk about race anymore. You can see this in schools across the country. They don't want to talk about race anymore because they don't want to be made to feel bad.
Right.
About what it is that they are benefiting from when it comes to, anti-Blackness, what it is their ancestors did to Black people, even if they themselves never owned slaves. And why should I be punished and not be allowed to get into school because of something that somebody else did?
Right.
It's just, the hypocrisy is really it's grinding my gears, Jess. It's grinding my gears.
Well, and so we'll be rewriting the law as we write our history, as we rewrite our curriculum, as we rewrite what we're allowed to discuss in public forums, all in the name of advancing a very particular Christian white nationalist space.
Yeah.
This is fun, super fun. Love it here.
Good times.
I have a question for you though.
Yes.
If and when the Supreme Court ends these kinds of policies, are there options for schools that want to make applications fairer for racial minority students, other than Kavanaugh's bad faith RFRA claim, like other than going for Jesus? Woke for Jesus?
I'm woke for Jesus. Oh no. Yeah, there is a thing that schools can do.
Yeah,
stop the legacy nonsense. End legacies. Right? Because who's benefiting from legacy programs? It's not a lot of Black folks.
Yeah.
I mean, I think Elie Mystal said on Twitter that I think both he and his wife went to Harvard. So he's like, yeah, my double legacy children are getting at Harvard and they're smarter than your dumb kids. But like, Elie Mystal is an outlier, right?
Yeah.
There are not a lot of legacies, Black and brown legacies that are going to Harvard, but there are tons of white ones, right? How did George Bush get into Yale? Not because of his grades, not because he was a smart man.
No.
Because he was a legacy. So that's one thing we can do. Another thing we can do, get rid of standardized testing.
Oh, God, yes.
What do we need the SATs and the ACTs for? We already know that there's racial bias built into the SATs. We know that there's racial bias built into school systems generally, to such a degree that some schools aren't even teaching kids how to think. They're just trying to teach kids how to pass certain tests. This is not a sensible way to educate a populace.
No.
It's just not. So that's
No.
the way to do it. I think that, obviously looking at things like socioeconomic class can help to a certain extent. But you can bet your bottom dollar that Students for Fair Admissions are going to be back in 10 years talking about how schools are using socioeconomic class as a stand in for race.
They
And one of the things that's so interesting about these affirmative action cases, right, is that the Bakke case, which was the 1972 case
Mhm.
that said, you can consider race, but you can't have quotas because
Yeah.
University of California at Davis Medical School was setting aside like 16 spots for Black
Mhm.
applicants. And the court said you can't do that, but you can consider racial diversity. So fine, you can consider racial diversity. And then Grutter says, yes, you can consider racial diversity if there's no race-based alternative. And then Fisher says, yeah, that's still accurate. And now we have a case a mere 5 years, 6 years later that's saying, no, you can't consider race-based, you can't consider racial racial and ethnic
Mhm.
characteristics and admissions. And then in 10 years from now, we're going to hear, you can't hear, think about socioeconomic status as a stand-in for race because, well, we know that they're going to start looking at statistics about the number of Black people that are this socioeconomic status and how it's really just a stand-in, and how schools, when they were trying to get away from the quota system, really picked up on the diversity system and really spent so many years and so many hundreds of millions of dollars trying to craft these policies. Now they're going to do the same thing for socioeconomic status, and that's going to be a problem in 10 years. I mean, I'm just rambling about that, but it just goes to show that nothing that these schools do will be enough when it comes to trying to diversify their student body until they cannot diversify their student body anymore.
Oh,
And I think
Imani,
that's the ultimate goal.
yeah, I don't think you're just rambling, though. I mean, you're absolutely correct. It is, we will see these cases. It's no surprise, as you said at the beginning of this segment, that we have this case now because it is part of a very specific network, an actual network of advocates and activists and dark money forces. Like, here we are sounding like all tinfoily, except it's real and true, designed to cook up challenges to legal precedent they don't like. And what's that legal precedent? It's anything that has allowed racial progress, that's allowed gender progress, any of it. And so we will see these baked cases as long as there is this kind of conservative capture of the court the way that there is.
Yeah. And I
There's
just want
nothing
to
to stop them. There's
There's
nothing to
absolutely nothing to stop them when you have these 6 justices who are willing to do whatever they are told to do. When
Yep.
you have Clarence Thomas asking the attorneys repeatedly, "So what exactly is diversity? I don't get it. I'm just a caveman lawyer. I don't understand your rules and your mores. What is diversity? What are there any educational I mean, I
That's a
understand that some
trap.
people. Here's what he said. I understand that people are in their feelings, is essentially what he said. I understand that people end up feeling bad, right? They go to school and they're isolated and yada, yada. But what are the actual educational benefits? I don't know, Clarence. Maybe when Black people go to a school and they don't feel badly about being at that school and they don't feel like they're oppressed and they don't feel like they're excluded, maybe that actually benefits their ability to do well in school. Like, is this a serious question? These are not serious people. These are
No.
people who have a goal, and they're going to get to that goal. And
Yeah.
these arguments, it was just, the tenor of the arguments was so just heavy and dull and pointless, right?
Dull is
The arguments
exactly it.
seemed absolutely pointless. Like, why are we even having what's going to turn out to be 3.5, 4 hours worth of arguments when we already know what the rules are? We already know what the outcome is. Just let Justice Jackson and Justice Kagan lodge their dissent and let's move on. We know what Alito and Clarence are going to say. Ugh. I just did a very Jewish grandma thing. Ugh.
You did. You did. But I do want to hear what your sort of highlights and lowlights were, because I mean, I do agree with you that the arguments in tenor were dull. It was like the most polite fight in the world, in that sense. But what'd you think?
I mean, obviously my highlights were just Justice Jackson. You could tell that she was angry.
Yeah,
Like,
you really
she was
could.
angry because and rightfully so. And I think that, you raised this earlier, but when she talked about how there may be an equal protection issue if a Black North Carolinian cannot talk about their Blackness in relation to their efforts to get into the University of North Carolina,
Mhm.
whereas a white lacrosse player can talk about how he's descended from, generations of blue blood white lacrosse players. That person can talk about that in their application, but the Black student is foreclosed essentially from talking
Mhm.
about their identity because the Students for Fair Admissions want this process to be something akin to, when you're auditioning for an orchestra. I played music for years and years in college, and when they were trying to diversify the orchestras, they stopped doing quote unquote blind auditions where you would just go into a room and you'd sit behind a screen and you'd have to play. There are all kinds of biases and microaggressions and shit that happens to you before you even get behind that screen to start
Mhm.
playing. Right. And so it
Mhm.
just doesn't make sense. And that's what conservatives want for these schools. They want race to not be a factor. They want race, if you're not white, to not be a factor.
Yeah.
And Justice Jackson calling that out was a huge highlight. What
Yeah.
was a low light for you? Because the low lights for me were Clarence Thomas. I've already expressed that. What were your low lights?
I mean, look, Sam Alito,
Yeah.
like, he's just kind of my low light of
And
2020.
generally, yeah.
I mean, I was anticipating racism from Justice Alito. I was not necessarily anticipating that we'd go back to the, one drop rule, that we would be looking at, I mean, he's such a partisan hack that even in his hypothetical, I don't know, maybe I'm reading too much into this, but took a swipe at Elizabeth Warren or ish, in the
Yeah.
sense of, well, what if there's lore in my family that I have Native American descent? Come on, man. What is that about? Right?
He
Like
also
that.
said something like, "What if I identify as Native American?" Which seemed to
Yeah,
me a like slam against trans folks. Like just the way
exactly.
he
Exactly.
emphasized that word was definitely a slam on trans folks.
He just sneers even
He
when
does.
he speaks. Everything just comes out as a sneer. And so Justice Alito, and then I mentioned Justice Amy Coney Barrett's whole, let me experience race. What's the experience of race like? Talk to me about that. It's bizarre, but I do want to give a moment to Justice Kagan because she was just not having it, and also not going to let Justice Jackson and Justice Sotomayor do all of the heavy lifting. And I think that's really important. As the liberal white woman on the bench, she needed to come in and take some body blows for them, I think, quite frankly. And she did. She was like,
Absolutely.
look, SFA, you're full of shit.
Yeah.
Frankly, like, to the extent that Elena Kagan would ever say that. And I mean, what I will say is that I think it perfectly encapsulates the fact that, we had prepared for this live stream and built in a bunch of time and all of this stuff, and we hop on and they were still talking about the first case.
Yeah.
Like, this is such a political and intellectual exercise for the conservatives on the bench, especially. And what the liberal wing is trying to do is just tourniquet where it can.
And what's fascinating to me is that in a pair of cases ostensibly about bias against Asian Americans,
I
nobody
mean,
was talking about Asian Americans. And there
literally.
are actually, I mentioned this on the Supreme Court preview podcast, right? There are
Mhm.
actually, with respect to Harvard specifically, there are policies that Harvard adopts that do harm Asian American
Mhm.
students,
Yeah, we've talked about this.
not because they're accepting too many Black students, but because of the regional characteristics, right? If you're like, I think I said, if you're an Asian kid in San Gabriel Valley, you're going to have a harder time than if you're an Asian kid in Des Moines. And maybe they talked about it during the Harvard part of the arguments. I doubt it, because the entire first hour, when it came to talking about Asian Americans were given short shrift if they were mentioned at all.
Yeah.
This was a case about tearing down affirmative action policies for the benefit of white students.
Yep.
And these conservatives were hiding behind Asian American students to do that.
Yep.
And I think we cannot forget that. They don't care about the number of Asian American students in schools. They don't care. They really don't.
They really don't. They really don't. Imani,
Yeah.
I I think we did it.
Did we
I
do it?
I think we did a successful live stream.
Yes.
I think so.
I mean, are we going to get off this live stream? They're still going to be talking and oral
They're still
arguments.
talking. The cases
They are
is
still
still going
talking.
on. And we're
Oh, for
like
crying out
45
loud.
minutes in.
Oh, for crying out loud. Well, we're just going to go end this live stream and
No
hey, maybe
more.
just
Good
go back.
vibes.
I mean, it's just all vibes and just shenanigans. But if you want to talk to us about these affirmative action cases or anything related to this new Supreme Court, well, I'm not going to say new, I'm going to say neo Supreme Court project in white dominance and white supremacy, you can find me on Twitter at Angry Black Lady, me on Elon Musk's new Twitter at Angry Black Lady. You can find Jess on Twitter at Hegemommy, HEGEMOMMY. You can and you should follow Rewire News Group. If you missed my live tweet, just go there and you can read it. You should follow us on Instagram and you should definitely subscribe to the YouTube channel here because that's how you're going to get notifications about our podcasts.
Do it.
And that's a very exciting thing for you to be doing.
So exciting.
Right? So what are we going to do then, Jess?
We're going to see you on the tubes, folks.
We're going to see you on the tubes and the YouTubes and probably back on Twitter where they're still talking about affirmative action.
Seriously.